Thank you, Taylor. Good afternoon. This is Christy Lawson. This afternoon, we're going to go through the Fair Debt Collection Practices Act overview, speak to you about who qualifies as a debt collector, a debt collection law update on California Debt Collection Licensing Act issues, and then Andrew's going to join us for a discussion of Hunstein and Alexander versus Carrington Mortgage Services. If you have any questions, please feel free to put them in the Q&A and we'll respond. I'll pick them up if I can as we go through, but if not, at the end of our presentation. Fair Debt Collection Practices Act is designed to eliminate the abusive and deceptive unfair practices by debt collectors. Debt collectors is a very significant defined terms, both not only under the FDCPA but under its state counterparts. The FDCPA is becoming more relevant as people turn to start using different types of debt collection methods than we've dealt with in the past. So debt collection by text message, email, where in the past it was phone calls and letters. Now we really focus on messages that come by text message, and so you have the overlay of the TCPA and other acts that you've heard about today. So just keep in mind that sometimes it's an overlay of different requirements when you're doing debt collection. The debt collectors as defined under the Fair Debt Collection Practices Act is more narrow than what you see in the state levels for multiple states. So it's important to understand your compliance requirements for the federal level and then still review it for each state in which you're actually doing the collecting. The debt collector for purposes of the FDCPA is any person who uses any instrumentality of interstate commerce in any business, the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect debts owed or due to another. So what's significant about the federal definition is the fact that the person is using instrumentalities of interstate commerce for the collection of debts and who regularly collects or attempts to collect debts owed or due to another. There is no defined standard under the FDCPA for what regularly collects or attempts to collect mean, as to whether it's 51%, is it 49%. It's primarily based on case law that the primary purpose of the entity is the collection of debt. The fact that the debt is owed or due to another means that it's owed, that the debt collector is acting as a third-party debt collector. There's some exceptions for when a subsidiary, affiliate, or even the entity to which the debt is owed may be a debt collector, and we'll touch on those. But for the most part, generally, it's when the entity is in the business of collecting debt and they're collecting for another entity. Businesses that collect their own debts, therefore, are exempt under the federal standard. The exception I just mentioned to you regarding when somebody can be collecting their own debt and still be considered a debt collector is when that collector is collecting under a name other than its own name. So if the debt collector is holding itself out as ABC Company for purposes of debt collection and their name is 123 Company, that would be an example of when they might be considered a debt collector under the FDCPA, although the debt is due to the company. Other exceptions to the definition of debt collector includes any person acting as a debt collector for another, both of whom are related by common ownership or affiliated by corporate control, if the person acting as a debt collector does so only for related entities that are not in the primary business of collecting debt. So this is what I refer to as the affiliate exception, that if you're related by common ownership, the legal definition of an affiliate, and collecting for another affiliate, then that affiliate gets the benefit of the exception that allows an entity to collect on its own behalf. Again, that doesn't apply if the affiliate is in the primary business of collecting debt. Any person attempting to serve legal process on a person in connection with judicial enforcement of a debt is also exempt. So your legal process servers would not be considered debt collectors just because they're serving notice of a debt collection action. Other exceptions include a person collecting debt owed or due to the extent such activity is incidental to a bona fide fiduciary obligation or escrow arrangement, concerns debt originated by such person, concerns debt not in default at the time it was obtained, and concerns a debt obtained by such person as a secured party in a commercial transaction involving the creditor. So from that, working backwards, the secured party in a commercial transaction involving the creditor, think of Article 9 and secured transactions. Concerns debt not in default at the time is a big one at the federal level under the FDCPA. If the debt was not in default at the time it was purchased, then that entity is not a debt collector and is actually gets to take the role as the creditor. Concerns debt originated by such person is important when you're dealing with original lenders and then servicers. So if the entity originated the debt, then they're going to meet the exception to being a debt collector. Some state debt collection laws may apply broader definitions, as I mentioned. Here in Florida, a lot of you might be familiar with the Florida Consumer Collection Practices Act, where the act itself has a list of prohibited activities that applies to any person that would engage in that prohibited activity. The definition of debt collector under Florida law is the same as under FDCPA, but the provision of the statute that says what's prohibited applies to any person that would engage in that conduct, not just to a debt collector engaging in that conduct. Similar is to that Florida concept of a collector acting as a person collecting or attempting to collect an alleged debt arising out of a consumer transaction is Maryland. So again, it's that person that could bring in other entities beyond third-party debt collectors, including the owner of the debt. The California Debt Collection Licensing Act defines debt collector to include any person who engages in debt collection on the person's own behalf and on behalf of others. So California, not shockingly, is more broad in that it also addresses when an entity is collecting on its own behalf, so is much more broad than the federal counterparts. Why is it important as to whether the entity qualifies as a debt collector is not only because of the provisions in the FDCPA and state counterparts, but they're subject to certain notice requirements and restrictions on communications, which can be enforced by the CFPB and by private causes of action. And keep in mind that it might also trigger state licensing requirements. If you meet the definition of a debt collector, you're acting as one, and you don't meet an exemption for a specific state, there's a good chance that you have to hold a license to collect in that particular state. A lot of talk recently about the California Debt Collection Licensing Act, the CDCLA. It amends the Rosenthal Act, so a lot of folks still refer to it as Rosenthal, but it's technically the California Debt Collection Licensing Act. Took effect on January 1st of this year. It applies to businesses that collect their own debts as well as those that collect consumer debts for others. So again, that broader definition. And consumer debt is defined as debt that's resulting from a transaction in which property, services, or money are acquired primarily for personal, family, or household purposes. One of the questions I think I get most often is whether association dues and fees are considered debt. Under case law that's in California and in other states, association dues and fees may be considered a consumer debt and would be included and covered if being collected. It's important to note, so I'm going to say it again, all persons engaged in the business of debt collection in the state of California must obtain a license from the Department of Financial Protection and Innovation, the DFPI. So California is certainly one of those states where you have to obtain a license if you're conducting any type of debt collection. There is some silver lining in that affiliated companies may be licensed under a single license. That came about after lots of questions to the DFPI during the drafting and after the law had been passed, but before it went into effect. So they've made that more clear now that affiliated companies may be licensed under that single license, and you don't have to obtain a license for each one of your separate entities. A management company collecting timeshare association maintenance fees is not subject to the CDCLA, but a developer or lender collecting purchase money loan payments, including for loans that originated, is. That's another important distinction. So a management company collecting timeshare association maintenance fees is not subject to the CDCLA, but a developer or lender collecting purchase money loan payments, including for loans that is originated, is, and that's due to the specific language of the CDCLA.
Christy, I will pop in real quick to provide the next CLE code. For those taking CLE credit today, please type the following 5-digit code in the polling box on your screen and record it on your attorney affirmation form if applicable, which can be found in the Resources tab on your screen. The code is S as in Sam, A as in Alpha, E as in Echo, V as in Victor, and I as in India. Again, S as in Sam, A as in Alpha, E as in Echo, V as in Victor, and I as in India. Please record this code in the appropriate places, and I will give it back to you, Christy.
Thank you, Taylor. And Taylor popped in right on a very important point, so I'm going to go back a slide. There it goes. That when collecting maintenance fees, keep in mind the distinction between maintenance fees, assessments, and then the underlying financing of the purchase. If it's a finance transaction, that's collected differently. Also keep in mind the distinction between who qualifies as a debt collector, and the exceptions for if you're collecting in California, that there's no real distinction between your own debt and collecting on behalf of a third party. Okay, with that, I'm going to turn it over to Andrew to talk about Hunstein.
Thank you, Christy. As Christy said, first case we'd like to discuss today is Hunstein v. Preferred Collection and Management Services, decided by the 11th Circuit Court of Appeals last fall. And I'll just lead off with a procedural note. The 11th Circuit granted hearing en banc last November, so the decision that we're going to discuss today has been vacated. But obviously, we don't know what the court is going to do on when it hears en banc. And in any event, this decision provides some good insight into how courts are looking at these aspects of the FDCPA. In Hunstein, the plaintiff alleged that a debt collector violated the FDCPA by communicating with the collector's third-party printing vendor regarding plaintiff's debt. The debt collector sent certain information regarding the debt to its third-party vendor in order to have dunning letters sent out. I'm just going to jump back here. The FDCPA at 15 U.S.C. Section 1692C sub B prohibits debt collectors from communicating debtors' personal information to third parties in connection with the collection of a debt. with certain exceptions that did not apply here. The 11th Circuit held in part, after a lengthy discussion of plaintiff's Article 3 standing, that the debt collector's transmittal of the consumer's personal information, in this case it was the consumer's name, outstanding balance on the debt, that the debt resulted from his minor son's medical treatment and the son's name. The communication of that information to the third-party printing vendor constituted a communication in connection with the collection of any debt. And as another procedural note, this case came to the 11th Circuit on appeal from the district court's grant of the debt collector's motion to dismiss. So at this stage, the 11th Circuit was presuming the truth of all facts alleged in the complaint and made this ruling regardless of whether any of the employees at the vendor actually looked at or made any use of the information that was provided to them. At the end of the opinion, the court recognized that this holding might force debt collectors to bring services like printing and mailing in-house, at least for a time, and recognized that that was a major upset to the industry, but nonetheless held that is the appropriate reading of the statutory text. And in terms of takeaways from this case, that is the first point, that this, regardless of what happens with this case following hearing on Bonk, this shows that the courts are inclined to strictly construe the letter of the law in the FDCPA, even where doing so might lead to unanticipated results like this one here that cause a major shakeup in the debt collection industry and overturn common practices like using third-party printing vendors. It is important to note, however, that the court left the door open for the possibility that this would ultimately be found to not be a violation of the FDCPA on the merits. As I said, this came up on an appeal from a motion to dismiss, and the court left open the possibility that discovery would show that the vendor's employees didn't, in fact, look at the information that was sent to them, read it, make any use of it, disseminate it further, and that in that case it is possible that there would be no harm and no violation of the FDCPA. Many of you are likely been following this case since last fall, and that this, given the disruption that this has the potential to cause to entities engaged in debt collection, that there may be a legislative fix in the works here to allow debt collectors to communicate with vendors. Also important to note that this ruling still gives room for consumers to consent up front to allow debt collectors to communicate with vendors in connection with collecting the debt. So that's always an option, to include those sorts of consents and disclosures in loan origination documents. Next case we're going to discuss is Alexander v. Carrington Mortgage Services, LLC. This one came out of the Fourth Circuit Court of Appeals earlier this year, back in the spring. This is a suit under the Maryland Consumer Debt Collection Act, which incorporates the substance of the FDCPA, but not necessarily the procedural elements or all of the definitions. As Christy mentioned earlier, this particular law has a broader applicability than the FDCPA. In this case, the consumer sued a mortgage service company alleging that the servicer had violated the MCDCA by charging a $5 convenience fee for monthly mortgage payments made online or by phone. Both the MCDCA and the FDCPA prohibit the collection of any amount, which includes interest, fees, charges, expenses that are incidental to the principal obligation, unless that amount is expressly authorized by the agreement creating the debt or permitted by law. And the important point of the Fourth Circuit's decision in Alexander, is that permitted by law requires affirmative sanction. It's not enough that the fees charged are permitted by law, or excuse me, permitted, I should say allowed by law, not unlawful. It requires an affirmative sanction permitting that the fees be charged. In that case, the defendant had argued that because the consumers had agreed to contractually agreed to pay the service charges through the ClickWrap agreement on the online payment system, that the charges were permitted by law, and the court held that that's not what permitted means in this case, and that it must be affirmatively provided for. Obviously, the key takeaway here is to make sure that any convenience fees or other fees charged in connection with debt collection are provided for explicitly in the loan agreements, and that it's not enough to have separate agreements like a ClickWrap agreement on an online payment system authorizing the payment. It needs to be in the loan origination agreement.
And I think what you're seeing in those cases is that courts tend to strictly construe the language of the FDCPA and state counterparts, but very rarely do you see the court sticking their neck out to rule in favor of a debt collector. Then more likely than not, the court's going to go out of their way to find an interpretation that protects the consumer. So we always recommend that when reviewing your debt collection practices, both at the federal and the state level, that you're taking a kind of broad read and review of both the law and the regulations to make sure that you're covering your basis and that you're complying with both the federal and the state laws. So with that, questions you can put in the chat. We're happy to review.
I'll just chime in real quick here. We have our prior presenters that will be jumping on the line shortly, so please feel free to add any questions from any of the presentations into the Q&A widget, and we will be happy to get back to you.
One point I just want to make sure I made clear, because I don't know if I really emphasized it, with the CDCLA, the licensing statute of California, that applies to when the debt collector has to be licensed and might apply to somebody collecting in their own name. That still doesn't mean, if you don't have to be licensed, doesn't mean you don't have to comply with the debt collection statutes. You still have to comply with the debt collection statutes and then separately look at the CDCLA to see if you have to be licensed. So it's just an overlay of, now you have kind of an additional requirement to think of when you're in California. And that's not unlike other states that have licensing schemes on top of it. It's just that California is a lot more definitive as to the requirements and when a license is required. And because it was applying to such a broad group of anybody collecting in their own name as well, that does kind of set it apart from other states. Right, no questions. This is an area we seem to get a lot of questions on. All right. We're Q&A for if there's any other questions on other topics. Andy is on the line. And other presenters are signing on for their questions as well. So if you have any questions, please post it in the Q&A for any of our segments, and the presenter will answer for you.
I'll go ahead and put our speakers' information on the screen. If you have any follow-up questions after the presentation, please feel free to reach out to anyone individually or any of your other contacts here, and we will be sure to follow up and answer any individual questions. But again, please feel free to, if you have any questions about any of the presentations, put them in the chat and our presenters will answer them. Thank you.
Well, I just want to thank everyone. I see there are no further questions yet today, but of course you can certainly feel free to reach out to any of our speakers with any follow-up questions you may have. I want to thank you all for joining today's program. We hope you enjoyed the presentations, and I hope it leaves you with a greater understanding of the issues facing the industry, and you'll take away some of our best practices for addressing them in your own roles. Thank you to our presenters for providing us with timely and informative insight into the impacts innovation and technology continues to have on the hospitality industry. So if there are no further questions at this time, I want to thank you all for your time today. Hope you have a great rest of your day. We're going to give you back 30 minutes in your day. And please be on the lookout for information in the coming weeks regarding your CLE credit for this program. Thank you very much for attending.